Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Today we're going to be discussing a June 12th, 2024 appellate decision that might have wide-ranging implications on hundreds, if not thousands, of other New York foreclosures. I'm Adam Friedman, managing partner at Friedman Vartolo, and joining me today is senior associate Stephen Vargas. Steve, how's it going today?
Great. Looking forward to discussing this case.
Steve has extensive experience litigating a wide variety of New York appeals and statute of limitations issues, and is a great person to have speak on this topic. The Coronavirus Aid, Recovery, and Economic Security Act, also known as the CARES Act, initially placed a stay on the foreclosure of federally backed mortgages. The stay commenced on March 18th, 2020, and was later extended all the way through July 31st, 2021. The decision I referenced in the intro is Trento 67 v. One West Bank. Steve, do you want to give us some background information on the case?
Sure. It's an RPAPL 15014 quiet title action commenced by the LLC to cancel and discharge One West mortgage based on the expiration of the statute of limitations. The result of that would be a total loss to the lender and the inability to sue.
Okay, and this one worked out in favor of the lender. This was a positive decision.
It worked out in favor of the lender.
Okay, and what was the key holding? What's the key point of this case?
The key holding was that the Federal Housing Administration's 500-day foreclosure moratorium from March 18th, 2020 through July 31st, 2021 told the statute of limitations. And the bottom line on that is New York has a 6-year statute of limitations to commence a foreclosure. Now, based on the FHA moratorium and this court's holding, it's a 500-day extension of that to make it a 6-year, 500-day moratorium to foreclose any FHA mortgage unless it's a vacant and abandoned property.
All right, so let's back this up because this is a big deal, right? So in New York, right, anyone purchasing debt in New York or handling foreclosure matters knows that the statute of limitations, the 6-year statute of limitations, is a really big deal, right? So what we're saying here is this case, which only pertains to federally backed mortgages, right?
Correct. In this instance, it's only FHA mortgages. There's an argument to be made that it could apply more broadly to other federally backed mortgages as well.
Okay. We're saying in this case, what's coming out of this case is that an extra ability almost, let's call it, right, to make it really simple, to extend the statute of limitations for whatever time you were stayed in your action. So if you were stayed for 6 months based on the CARES Act moratorium, you're getting 6 months added to your statute of limitations. This could be very effective, it sounds like. This could be very helpful in a lot of different
Absolutely.
situations.
You're talking about a tolling period that's approximately a quarter of the actual statute of limitations itself. So adding 500 days to a 6-year limitations period is very significant, particularly when there were loans that could have been foreclosed had it not been for the moratorium, and that limitations period was near close to expiring in 2020 when this occurred, when the COVID pandemic occurred.
Now, you mentioned this applies to FHA loans, possibly federally backed loans. Like, where are we exactly?
It applies absolutely to any FHA-backed loan, except for those properties that are vacant and abandoned. It includes situations where the borrower passed away, which is actually what the situation was in the Trento case. So the fact whether the borrower is alive or not doesn't matter. It applies to FHA forward and reverse mortgages as well. An argument can be made based on this holding, and an argument should be made in litigation for any other government agency-backed loan, so let's say a VA or USDA loan, that this holding applies to give them the same 500-day extension. An argument should also be made, though it's not conclusive that the argument would be successful, for any Fannie Mae and Freddie Mac loan that, because those are government-sponsored enterprises that had a virtually identical moratorium, the 500-day tolling should apply in foreclosures of those mortgages too.
Let's just say there was a random city in New York that somehow had the power to just stay foreclosure activity for a period of time, right? Could this argument be used? Could this decision be used to make an argument that any type of government moratorium or stay should toll the statute of limitations? Like, is that where you think this is going?
It could be. That would in part be fact specific or dependent on what the exact moratorium was, but absolutely. A case like this, litigants and servicers should be looking at this case and trying to argue it applies as broadly as possible. And then based on the facts of a moratorium, the specifics, the duration, it may be a successful argument, but this case not only can be used for FHA, but should be used in more broad arguments. So I think it potentially has a very broad positive impact on the industry. And like you mentioned initially, every government-backed loan would be impacted by this. And the extent of the impact is obviously dependent on whether the SOL was going to expire soon or whether there's a recent default. But, for certainly hundreds, if not thousands of loans with default dates that were, 6-7 years ago, this could prevent a total loss.
All right, so you mentioned also this was a case of first impression. Just really simply, can you just explain to our audience what that means?
It means that it's the first time an appellate court in New York decided whether the CARES Act moratorium combined with the actual government agency moratorium told the statute of limitations. Several trial courts had ruled on this, but the trial court authority is not binding on any court. This appellate court authority is now binding on every trial court because it's the first time an appellate court ruled on it. And that's extremely favorable because in order for this not to be binding, another appellate court would have to rule that the FHA moratorium did not toll the statute of limitations. And I think this appellate court was very persuasive in reasoning why it did.
Okay, so we're saying since it's first impression and there's nothing contradicting it, every lower court needs to follow this decision.
Correct.
Okay. All right, to recap, this decision has an immediate impact on FHA New York loans and has the potential to have an even greater impact on all loans that were at some point subject to a stay or a moratorium. Thanks for joining Stephen Vargas and I on the Weekly Friedman, your source for the most essential information in the default industry. As a side note, late last week, Steve put out a memorandum on this topic. So if you need any additional information or just want to read further, please feel free to email him directly. We'll make sure his contact information is below in the comments. Additionally, please like, comment, make suggestions. We're always looking for future ideas for our next topic. Thanks a lot and have a great day.